To get started here, my name is Josiah. I am the Legal Information Director of PARSOL, as well as the Education Director and the Chair of the Board. I've been with the organization from its beginning, and I have seen a lot of progress with the organization and with a lot of new members and a lot of questions that have come up in regards to sexual offense laws. What do we have in Pennsylvania? But before we get into what do we have in Pennsylvania, when I was doing my research, I found actually the better question is to start out with is what don't we have in Pennsylvania? So we do not have residency or zoning restrictions. We do not have Halloween restrictions such as putting up signs saying, hey, don't send your kids here, don't have your lights on. We don't have those. We do not have SVP civil commitment, as was discussed earlier, for inpatient, but we do have for outpatient. And I need to keep on remembering to name it as outpatient, but I'll get into that a little bit here. We do not have chemical and surgical castration. We do not have a driver's license designation that says sexual predator. We do not have a mandatory GPS monitoring system like some states have. And also we do not have the death penalty for certain cases of rape. That does not mean that these laws have been proposed. Some of them have been proposed in our state General Assembly. We have submitted research and documents to say, hey, look, this is not a good idea. Last September, before the General Assembly House Judiciary Committee, there was a residency restriction bill that was being discussed. We were there. We submitted a one-page info sheet, and all the experts who were there said, hey, look, this is not a good idea. And our paperwork followed the exact same thing. And so far it looks like it is still in committee, and it looks like it's going to be dying in committee. Same with the chemical castration and a few other little things here. The death penalty, those have been proposed in Pennsylvania, but it looks like they're probably going to die in committee as well. Now, in regards to GPS monitors, it may be a condition of probation or parole. It is also in Title 42 of the Pennsylvania Consolidated Statute Section 9799.3. Again, written in there as a possible mandate by supervision, but if you're not supervised, you don't have to worry about that. Now, a word of warning to, okay, there we go. A word of warning to those who are thinking of creating any of these policies and passing them within our legislation. Think of this from Milton Friedman, who was a great economist. One of the great mistakes is to judge policies and programs by their intentions rather than their results. Meaning that what might seem like a good idea with the right intentions behind it may bring more unintended harmful consequences to the individuals, their families, and the communities. So it is important for policymakers to know that implementing these policies that are inconsistent with empirical evidence and best practices runs the risk of creating a false sense of security that something constructive is being done. So where can we find these laws? Well, Title 18 of the Pennsylvania Consolidated Statute is the crimes and offenses. That's where you will find the offenses individually within their chapters. In Title 42, the judiciary and judicial procedure is where you will find SORNA, and you will find Act 21. Act 21 is the statute where it provides for the sexually violent delinquent child, SVDC. And that is a system for where individuals who are minors, where they have been adjudicated as an SVDC by the SOAB, the Sexual Offender Assessment Board, where they have a mental abnormality or personality disorder that makes them more likely to reoffend. They are given that title. They go through the judicial system for minors, and then when they age out of that, then they go into a civil commitment inpatient. And then every year they get a reevaluation to determine, do they still need to be within the system, or can we now process them out so that they can get outpatient treatment? As I said, the main regulation that we have in Pennsylvania is SORNA. But before I get into our state, let me just go briefly over the federal, because the federal has a big impact on the creation of our state Commonwealth registry. In 1994, we had the Jacob Wettering Act. It was a private-only registration. And then in 96, we had the creation of Megan's Law, which then was made it from private to public. In 2006, we had the Adam Walsh Act, also known as the Sex Offender Registration Notification Act. This added the DNA database and the civil commitment component that a lot of states have adopted. And then in 2022, the Department of Justice implemented the new SORNA guidelines to where states have to implement a 3-tier system. Now, the federal SORNA is the foundational blueprints for the state and territorial registries. If the states want to go above and beyond that, they most certainly can. But if they fall short of these guidelines, then they can lose some federal funding. But there is a provision, and it is important to understand, especially to our state legislatures. There is a provision where if the Constitution or the courts say that you cannot have a certain provision within your statute because it's unconstitutional, there is an exemption within the federal statute that says, okay, we can overlook that as long as you make some kind of reasonable accommodations to make something as close as possible to this, if you can. If not, we will not withhold that federal money from you. So now going into the Pennsylvania's registry system. In 95, Governor Tom Ridge signed into law Megan's Law 1. The problem with Megan's Law 1 was that everyone who was put on there was presumed to be an SVP, again, sexually violent predator. And it was up to the defendant to prove otherwise. The burden of proof was on them, which is backwards to our due process. And so because of that, it was ruled unconstitutional. And then the General Assembly came out with Megan's Law 2 in the year 2000, where it was then the SOAB had to prove that the individual had a mental abnormality or personality disorder that made them likely to reoffend. And on top of that, there was more reporting guidelines in Megan's Law 2 than Megan's Law 1. Then, in 2004, the General Assembly expanded upon the registerable offenses, therefore creating Megan's Law 3. See a history here, a pattern? And it also added, imposed harsher penalties for failure to register. Now, Megan's Law 3 was ruled unconstitutional because it violated Pennsylvania's Constitution, Article 3, Section 3, single subject rule, which states No bill shall be passed containing more than one subject, which shall be clearly expressed in its title except a general appropriation bill or a bill codifying or compiling the law or a part thereof. So what was the provision? Asbestos removal. Made no sense. And the Supreme Court of Pennsylvania, which I will be using SCOPA for it, said, yeah, you can't, that's not going to fly. So then in 2012, we had our first version of SORNA as a result of the 2006 Adam Walsh Act. And this introduced a three-tier system in the Commonwealth. And it was ruled punitive in the case of Commonwealth versus Muniz, and therefore it violated the ex post facto clauses of the federal and Commonwealth's constitution. So as a fix to the issue, in 2018, they passed Act 10 of 2018, creating SORNA 2. And this brought in addition to subchapter I. In Title 42, Chapter 97, subchapter H is where you will find the original version of SORNA. But then they create a subchapter I to capture those who would have been given relief under Muniz. Now, the important date to remember is December 20th, 2012, because that's the date when SORNA 1 was enacted. So anyone who committed their offense prior to December 20th, 2012 would fall under subchapter I, because it was the fix where it would be less punitive, so that it would be a civil nature penalty. So there were less reporting requirements. There was a new alternative reporting procedure for those who qualify, where you can call in telephonically. But now currently it's where you can do it online on the Pennsylvania State Police maintenance law website. And actually that provision is under subchapter H, but they have it applied to those who are on subchapter I. So the thing that we are now working on is, okay, we need to get the Pennsylvania State Police to create the same thing for those who are on subchapter H. And subchapter H is applied to those whose offenses were committed on or after December 20th, 2012. And then also, the General Assembly created a removal mechanism that after 25 years of being on subchapter H or subchapter I, you can petition the courts to be removed. But this is only applied for individuals who are tier 3, which is a lifetime, or you're on lifetime in subchapter I, or you're deemed as an SVP. Those who are those who are on tier 1, tier 2, you're going to be off before that 25 years. So it's really a nothing burger. So who is SORNA applicable to? I do apologize for some of the overlapping that I just see here. Some of the formatting didn't go right through, I guess, when John downloaded this. It is applicable to Pennsylvania residents who have been convicted of a registrable offense, and the term resident is defined as, or residency is defined as a location where an individual resides or is domiciled or intends to be domiciled for 30 consecutive days or more during a calendar year. And this also includes visitors. So if you plan on visiting here for a month and you're on the registry from another state, you have to register here. If you are employed in Pennsylvania, whether you live out of state or in state, you have to register. If you're a student in Pennsylvania who has been convicted of a registrable offense, you have to register. But the term student does not mean the term student, there is an exclusion. If you are doing online classes and it's all strictly online, you do not need to register that. And then also transients or those who are homeless have to register as well. And incarcerated individuals who are previously required to register under Megan's Law from another state or from another version in Pennsylvania also need to register as well. So subchapter H, as I said, is for those whose offenses occurred on or after December 20th. And this is the 3-tier system, where tier 1 is 15 years and you have to register once a year. Tier 2 is 25 years registration and you register twice a year. And tier 3 is a lifetime registration where you register quarterly. Now, this is not an exhaustive list of the full list of offenses. You can go on to the website and take a look at the full offense list on the Pennsylvania General Assembly website or even on the Megan's Law website. They have that all there as well. And if you take a look under tier 1, the first 4 offenses are non-sexual in nature. They are unlawful restraint, false imprisonment of a minor, interference with custody of children, and luring a child. But yet, even if you commit one of these and you have not done anything sexual to a minor or had no sexual intentions of committing anything with that minor, you will still be put on the public registry as a sexual offender.
To an outsider, what is corruption of minors?
Very broad.
Very broad,
Could be
yes.
anything.
Yeah,
Corrupts or tends to corrupt the morals of the
yep.
So it's prosecutor's discretion, basically.
They just tack it on there.
Hmm.
Same with invasion of privacy then too.
Now subchapter I, this is for those whose offenses occurred prior to December 20th, 2012. As you see, it's either 10 years registration and you register once a year, or it's lifetime registration and you register once a year. And this is more resembling to Megan's Law 2 than it is than all the others, because that was the most common version of Megan's Law that people fell under, and the one that upheld the more constitutional aspect than the other 2. And again, the full list of offenses you can find in section 9799.55 or also on the Megan's Law website. So what do these 2 subchapters have in common? Well, they both have the SVP designation, which is a lifetime registry, but you register quarterly as well. And you are mandated to go to outpatient civil commitment treatment therapy for the rest of your life once a month. Those who are deemed SVDCs, again, same thing. They are a lifetime registry. They have to register quarterly. And there's that civil commitment part where after they age out the juvenile system, then they go automatically into a civil commitment. And every year they get reevaluated to determine if they can then leave the internal civil commitment inpatient treatment and then go for the outpatient. I saw a hand raised.
Yeah, the treatment that they have to go for a lifetime, who pays for that?
So that is up to first the person themselves. They have to pay for that, as well as the yearly polygraph that is mandated by the SOAB.
So it's all their responsibility.
It's all their responsibility. Now, there is a provision where if you are indigent, you have to prove that you're indigent and you can petition the courts for the system. I guess it would be the Department of Corrections or probation. Thank you, probation or parole
Office of probation.
to pay for it. If you're on state supervision, At the time while you're on supervision, you can ask them, and the probation officer will most likely say, yeah, we can cover that while you're on here. But then if you fail a polygraph and you have to take a second one, that payment's on you. And that can be anywhere from $400 to $600 per test.
And did you say that continues for life as well?
Continues for the rest of your life. And if you miss 1 month for whatever reason, whether it's for health, physical therapy, whatever it is, and you cannot make it, that's an automatic, and I'll go into that as well. It's an automatic misdemeanor 1. No exceptions. If you miss a counseling session as an SVP or SVDC.
Yeah, question about the assessment. So is that assessment just like a scoring model? It's not, or is it something more technical like the MMPI?
Not at all. There is no scoring
We don't meet
whatsoever.
them at all, right?
An individual.
You do that. I spoke with the SOEB about this. And they said, we don't even need to interview the individual. We could just take a look at the paperwork from the
So it's
courts, from the
objective
police.
assessment.
The police report.
Yeah, we can take a look at the police reports. We can take a look at the victim statement, everything.
That's unethical.
And
I mean,
Welcome
as a
to the legal
counselor, you
system.
to abide by ethics.
that's the issue that we've been trying to present to them, and that we've been having some discussions, and hopefully we'll be able to make some other kind of changes from the previous SOAB regime that we've were in discussions before or tried to before. We were getting nowhere with, but with the current group that we have been able to get more information. But they've been, I don't want to say, what's the best way of putting it?
You're not first priority.
It's not that we're not first priority, it's they are making some changes, but they're still going by with what the statute says. A lot of this is where they are bound by statute, but a lot of it is where it's their own policy as well. And they are saying, oh, our hands are tied by the statute, when they actually have a lot more leeway.
Can I ask a question just so I can delete it?
Yep,
That Munez case,
Muniz, yep.
so if you had a crime before 2012, could you fight according to that case?
No, you would be put on subchapter I. Because it is because subchapter I has been deemed non-punitive, and I'll go into that case a little bit later. And for the sake of time, please hold questions until the end, so because Randall also has to share and make sure he gets time too. Also, under subchapter H, those who are transient homeless, they have to register monthly. And that is across for all tiers. Yep. Now, how do we make sure that that everyone is in compliance and that these are enforced? So for tier 1 and 10-year registrants or persons forced to register, if it's your first time that you did not go to your window and register, or you did not register anything that is required within the 72 hours, like a phone, email, whatever, the first time, and it is non-intentional, it's a felony of the 3rd degree. But if it's your second time, or if it's your first time and it was intentional that you knew that you had to go and you did not do so, it is a felony of the 2nd degree. Then for tier 2, 3, and lifetime registrants, same thing. It's a felony of the 2nd degree, though, for non-intentional and your first time. But it's also for your second time, or if it's where it's your first time and you did not, and you intentionally withheld the information, is a felony of the 1st degree. And then again, failure to attend counseling, misdemeanor 1. And whether again, whether it's by act of God, health, natural disasters, whatever. If you do not go and register, you will be held liable. You will be charged, and that is in the statute. And that is one of our projects of where we want to change that within our legal system and our that's one of our priorities and our policies for the legislation committee and legal committee. And then also the state police will make home visits. They select certain counties where, okay, this is where we're going to be doing it this year, and then we'll go to these other counties for the next year. I've had a couple of knocks on my door as well, and the heartbeat. So these are the latest key cases that shaped our legislation, shaped Megan's law, shaped our other policies. Commonwealth versus Muniz was where SCOPA found that SORNA 1 was found to be punitive and in violation of the US and Pennsylvania ex post facto clauses to those who had to register for individuals whose offenses were committed prior to December 20th, 2012. And I will ask John to put these slides available on our website as well. Commonwealth versus Butler, also known as Butler 2. Mr. Butler challenged the SVP designation and the requirements and the SOAB and all of that different stuff. And they said the counseling, the notification requirements, what did not constitute as punishment, it remains a civil collateral consequence, and therefore it can stand as is. In Commonwealth versus Lacombe from 2020, this is where subchapter I of SORNA 2 was challenged. And the Supreme Court of Pennsylvania said it's non-punitive. It can stand as is, even with the minor fixes. Then, in a disastrous decision of Porcelari, subchapter H was ruled as non-punitive. It did not violate any due process. It was not. It did not violate our Pennsylvania's Article 1, Section 1, right to reputation. And so the whole thing as is currently stands. How am I doing on time?
We should wrap it up.
Okay. And then these are the last key cases. Commonwealth versus Santana. Mr. Santana, he was coming from New York to Pennsylvania. His case was before December 20, 2012, they put him on subchapter H. He fought that and said, no, I should be on subchapter I. The ex post facto should not just apply to individuals who live in the Commonwealth, but also to individuals who are out of state. The Pennsylvania Supreme Court agreed. Then you had Frost versus County of Allegheny and Lake Naomi Club Incorporated versus Roseto. The County of Allegheny and the Lake Naomi Club had residency restriction policies. And these two cases are why we do not have residency restriction policies in Pennsylvania. They said that the courts said that those policies are in conflict with presumption doctrine, meaning that when a lower government law and higher government law conflict, higher law displaces or preempts lower law due to the supremacy clause of the Constitution. Our state legislatures, our probation, the policies of the probation and parole state that, hey, we need, as part of reentry, we cannot have these. It is part of where we need to let people come in, exit, and get housing. By putting these barriers up, we ruin their chance of reentry. and the courts have said, yeah, they're correct. So the scope and Commonwealth Court decided the enforcement of residency restrictions in practice contravenes the goals and purposes of SORNA and the sentencing and parole codes. Two frequently asked questions that we get, especially since we just had the election cycle, is can individuals convicted of a sexual offense or other felonies in Pennsylvania vote? Absolutely. You may vote as long as you lived in Pennsylvania for 30 days prior to the election and are not physically incarcerated. So if anyone tells you because you have a felony and you cannot vote, that's BS. You have that right. Sorry. And the second question is, are there restrictions around living near or visiting schools, libraries, public parks, etc.? Answer is no. However, again, probation and parole may implement such restrictions. And then also for schools, if you have a child that is in public school and you want to go and see your child's play, the school can say, hey, we're not allowing you on here. But there also has been provisions where I know of parents who have gone to the school and said, hey, if I make a safety plan and we work something out, can I still come? And most of them will say, yeah, if we can work something out, create a safety plan, sure.
Sorry, I forgot.
Yeah. And so these are the final list of resources that I have found my information from as well. And I think you'll find them useful too. And again, this will all be put on the website. Randall, you're up. And again, I'll answer questions after he's done.
Pulling up my notes here. What a great turnout. Thank you all for coming, and particular gratitude towards our public servants today. All of you working towards reentry and working in our prisons and probation. And thank you to the public servants. So I am the legislative chair for PARSOL, and I kind of came into this role, one, because of proximity. I live in Harrisburg City and very close to the Capitol. Two, because I worked with another organization which taught me, the ropes on what lobbying looks like, and meeting with your senator looks like, and meeting with a representative, and what like committees, mean, and what all that, what that process looks like. And so that's how I came into this role. Came into PARSOL in 2018, and I joined because I found such great value from NARSOL when I was serving a sentence, 2010, 12-ish. I used to get the NARSOL newsletters all the time in prison, and it was really nice and reassuring to see that people were out there who cared about this issue and had expertise on it. And I when I came out, thought, how can I give back and give that to people and give them the kind of hope and opportunity of change? So I wanted to talk about legislation and kind of give an overview on how things work, and talk about our agenda for what we hope to accomplish in the General Assembly of Pennsylvania, that is the House of Representatives and the Senate. And talk briefly about our wish list for other things we'd like to see. So in a nutshell, Pennsylvania has 2-year sessions. So every 2 years, the clock resets, so to speak. So laws get proposed and passed or not in a 2-year period. You got 2 years as a lawmaker to pass a law or not. And we are right now at the very end of this session. So December 31st or so will be the end of the 2023-2024 session. So kind of what's been happened, or what is going to happen, has already happened. It's a wrap. So we're coming to that reset point now. And, it gives us an opportunity to kind of get in on the ground level and push what we want to push for. And on the other side, unfortunately, some of the things we wanted to see pass are not going to pass. And, that's not just our stuff. That's, around the state, people who have reforms and wish lists, vast majority of them don't happen. We have 2 chambers, of course, the Senate and the House. The House needs to vote on bills and proposals and pass it through their committee structure and through their voting process. And once that happens, the Senate needs to do the same thing, and it needs to be agreed upon. And if both chambers agree on something, Then they send it to the governor signs it or vetoes it. And that's how we get a law passed in Pennsylvania. We have had a divided government for the last 2 years, and we will continue to have a divided government. That is, the Democrats have the House, the Republicans have the Senate, and the Democrats have the governorship. And so there is, disagreement, of course, on very like basic levels, and so not a lot gets done. And this is not, unique to Pennsylvania. This is, how a lot of state governments work. So on one hand, it's kind of too bad that a lot doesn't get done, but on the other hand, it prevents any kind of like extreme agendas on either end to get passed, right? So it's more like moderation, but again, a lot of like stalling. So how it's supposed to work is, right, we have 203 members of the House, we have 50 members of the state Senate, and if a majority rules, then that's a law, right? That's how it works. If 102 out of the 203 wanted to pass, and it'll pass. And if 26 out of the 50 wanted to pass, and it'll pass, and that's how it works. But that's really not how it works, right? We have a very kind of oligarchic system where it's very top heavy, where the leaders of the parties really call the shots. And you have about 6 to 7 people in either side, the Senate and the House, who like matter and whose opinion matters. And if they want it to pass, it'll pass. And everybody else is really just kind of there like to cast a vote. And don't get me wrong, they still serve their communities, they're still public servants, they still want to see good things brought home to their home districts, and they provide services to constituents. But as far as like what is going to get passed as a law, that's very top heavy. And so who are the people that matter? Well, it's the Speaker of the House, it's the majority leader of the House. Right now, those are Democrats. So if you want something done or to move, you better have good relationships with the Speaker of the House and the majority leader of the House. Also influential are the chairs of the committees. So we deal with sex offense laws and crimes and things of that nature. So we have developed relationships with the Judiciary Committee. Health and Human Services isn't as relevant, or the Insurance Committee isn't as relevant to what we're trying to accomplish as the chair of the Judicial Committee. So that chairperson has his own leadership structure where their own committee is not going to hear anything unless they want that to happen. But before they want it to happen or get the okay, they need to get the okay from leadership, right? So it kind of all goes back up to leadership. And I just point out to say that is unfortunate in some regards, and it's really not very democratic or majoritarian. But on the other hand, it makes it a little easier to like get what you want done. And it sure helps if you have, millions of dollars, which we don't have, to get this done, because all you need to do is target a few people. You only need to target 6 or 7 people. You don't need to target 253. You only need to target, 6 to 10. And if you can get them on board and finance them and give them the perks and what they need, then your measures will tend to pass, despite public opinion. And if you don't have those people on board, and if you don't have money or influence or are able to threaten their next election, then you're going to get overlooked. And so obviously we fit much more into that second class. We're not that influential yet. We're doing all we can. We've partnered with the state as far as the Pennsylvania Reentry Council, and we have plenty of evidence and stories on our side, but we don't have millions of dollars, and we can't say we exactly have like a grand constituency, which is going to threaten your election if you don't do what we ask, or if you don't, listen to the science. That, at the end of the day, is the only thing that is really going to motivate a legislator. Am I going to get elected next session or not? Can you threaten their next election? And right now we can't, right? All we can kind of do right now is ask nicely, present the best evidence we can, appeal to their compassion and to the science, and go through those methods. But as we grow, and perhaps we'll have some more influence, and we can have some more success. So we talked about the gatekeepers. As far as our agenda for this year, what do we want to do? Like I said, it's going to be a new session. We're going to be starting over. We want, as pretty much our number one priority, to propose a review process for people on the registry. So there's a lot of things that we would love to see implemented. Dr. Gerstad talked earlier about protections for senior citizens, because a lot of nursing homes won't allow you to have care if you are on the registry, or if you have a sexual offense in your past. We'd love to see some legislative protection for this population, have it in law that no, you can't deny people. That's something we'd love to see done. Another thing on our wish list would be compassion for people with intellectual and developmental disabilities. Some people with IDDs have wound up on the registry. Maybe they've committed crimes, but they don't exactly understand or appreciate what they've done. They don't deserve to be on a sex offense registry, let alone for the rest of their lives. Is there some way that we can have some compassionate consideration for these people? Put that into statute. If you have confirmed IDD, how can we better work with you to be more reasonable here and better reflect what our aim is, right? Public safety. Another thing on our wish list would be interstate cooperation. So right now, if you come from Arizona and you want to come live in Pennsylvania, there's a series of question marks surrounding what is the process here. Am I going to be on your list for another 2 years, even though I already did 8? Is my crime registrable in your offense? Do I have to be, on subchapter H or subchapter I, which Josiah talked about earlier? All these question marks, and it's really kind of like, well, I don't know. And it's like a case by case basis, and there's not a lot of consistency here. So we'd love to have some kind of interstate cooperation and clarity for people, for if you're going to move or move out or move in, what do I expect, what's going on, and what is the plan here? So that's another one on our wish list. But to get back to the relief mechanism, that's kind of the one that we want to focus on first. And, we can walk and chew gum at the same time. It's not to say any of these other things aren't going to happen, but we want to focus on the relief mechanism. So as Josiah explained, we're on for 10 years. Some people, not many anymore, 15 years, 25 years, or a lifetime. And just kind of on its face, when you consider what does that mean? It means that people in their 70s, 80s, 90s, or older, probably not many older, we're not getting much past 90, but they're going to be on our list, the sex offense registry, registering at the state police office every quarter, every 3 months. You're bedridden and you're going to be, listed on a sex offense registry, and this is nonsense, really. So, and that's an extreme example, but we can also talk about, Romeo and Juliet cases, if you will, where young people make bad decisions and now they're potentially looking at 25 years on this public shaming registry, which is going to, really affect their lives and their livelihoods. So to kind of put it in a nutshell, how can we have a review process for people who have wound up on this registry? Right now, as Josiah mentioned, 25 years, that's your review process. You can petition maybe to get off in 25 years, maybe not. And that is a lot of time to wait. As courts have put it, that's kind of the prime of your life gone. After those 25 years now, a lot of people have not had those career opportunities that it might have developed in their 20s or 30s. And so that is way too long. So what's a better number? 2 years, maybe after you're released from the community and you've been able to demonstrate change. Maybe it's 5 years, maybe it's 10 years. I don't know this number. And, this is something we're gonna have to negotiate. And the legislature and, the tough on crime people, we're gonna wanna say, 15 years, 20 years. It's better than 25. And more progressive people and people with, research and knowledge on their side, they're gonna maybe advocate for 2 years or 3 years. And what will this number be exactly? I don't know. I pretend to know, but this is something we want to develop and explore. And again, what do we want to do? We can set it as a messaging of let's capture or have this list proposed for the ones that actually are a high risk, right? If we are able to give people a way to get off of the registry after they've proven, again, you've completed treatment, you've completed probation, you've completed parole, I'm not a safety risk, I have community, I have a reason to be offense-free, then we can potentially get you off the list and make this list more serving or more capturing people who are genuinely high risk, maybe people who just got out or maybe haven't completed their, requirements or repeat offenders or what have you. Anyway, the idea of shifting it away from a broad net that captures everybody, and it doesn't matter the circumstance of your life, to let's capture people who have demonstrated higher risk. So that's what we're working on with the legislative committee for the next session, and that's again a 2-year session. We encourage you to get involved. The more that your representatives can see your face and know, people with common issues and how it affects their lives, the better. Again, like I said, it's very top heavy, but people talk still, right? And rank and file members of the House and the Senate, your representatives, they talk to leadership and they're not totally irrelevant. So it never hurts to make your presence known and to meet with these people. And, it's your right to, they represent you. So I encourage you to join us and get involved there. So that brings it to the end. And Josiah, if you want to come up, we'll take some questions. Yeah, Andy.
First, there's some questions in chat, but my first question is, when going to talk to a legislator, I know you said that people in Pennsylvania can vote, other places cannot. Do they still represent you even though you might not be eligible to vote?
Wow, that's a fair question. I would say yes. They are state senators, they are state representatives, and so they represent the state of Idaho or Pennsylvania or Ohio or what have you. And so yes, they do still represent you. It's I see your point, but yes, they still represent you.
And as such, when you go speak to them, should you go in there like throwing Molotov cocktails at them, telling them what schmucks they are? Or, should you dress up in a tuxedo? How should you actually present yourself to them to bring in your issue? Should you bring in a binder of all of your issues?
Yeah, that's a good question, and yeah, of course not, presentation matters a lot, and while they are public servants and they are, it is their job to see you, they don't have to see you, right? They can make up an excuse as to why they're too busy, or, well, are you actually a constituent, do you live in this district? Well, we don't want to see you. And so they can, put up barriers if they want. So yeah, you want to go in with the fig leaf, not the arrow, right? As far as the tuxedo, that's a bit excessive. These people are, men and women just like anyone else. They put on their shoes in the morning. They're no different than you. They actually know probably a lot less about this issue than you do. So I would go in kind of wearing what you would usually wear, maybe something a little nicer, go in with a good attitude and grateful for their time. And as far as the binder of issues, no, that's never a good idea. In my opinion, think about if somebody brought you a binder of issues, with like stats and data to read about whatever you are an expert on or whatever you're responsible for, right? Who has time to do that, right? What I would much prefer if somebody came to me asking for help is, more concise and, get to the point. And what do you say? Well, that's like where our website would come in handy, or reach out to one of us and we'll help you like with your talking points. What do you want to talk about? What should we talk about? What's relevant? What's not?
And we have on our website a list of our policies with the talking points. We also have other resources with fact sheets, brochures, fact cards that you can print out on your own and study those, memorize those, make them, put your story to it and share that with your congressman or woman.
Yeah, and I would like leave those materials afterwards. I would
Yeah.
like talk to them when you can for the 15 to 20 to 30 minutes that you get, and then when you leave, say, hey, I'll send you the brochure. That's what I would do. Yes.
I would suggest, following up on Andy's question, if you don't get them with your elevator speech, if everybody knows what that is, forget it. A lot of times you're getting half attention. Having done some advocacy, you're getting, their outlook generally seems to be, I'm doing you a favor by giving you this 10 minutes. What do you have to say to me, and make it quick?
Yeah.
So, and I'm sure coming from Connecticut, I bet it sounds like it's exactly the same in Pennsylvania. I'm sure it's the same in Indiana and Florida, et cetera, et cetera. These are people who have a lot on their plate.
Yeah, it's a mixed bag. I've met people who, have a big head, so to speak, and have been there for maybe too long, but I've also met people, and there's one of them in the other room, who are, who truly care about what they're doing and want to help and will invite you in their office and say, why are you leaving so soon? I can talk to you. Totally. I've talked to somebody from Lancaster County, Rep. Smith Wade L in particular, who's, very welcoming and doesn't care if you're constituent or not, is willing to talk to you.
Are they considered, last point, are they considered full-time legislators here?
Yes, we do have full-time legislator.
Going back to my question earlier about the forced group for a lifetime, is there any way to force the insurance companies to pay for that, or get the government to pay for that, to attack the money side of what they're doing?
Your private insurance may cover it, but you can't like force
The
anybody.
private insurance will cover it? I mean,
Oh, yeah.
they will?
I've had
I
private insurance
never
cover my
Okay.
Yours does?
Yeah.
Your kids?
County insurance. That's
Or
not
county
private.
insurance,
That's
yeah,
right.
not-
That's
not-
public,
not-
right?
Not,
Yeah, I'm
not
talking about
private
county.
insurance, right?
Yeah, I'm
Private
talking about
insurance
private.
doesn't cover
Yeah, good point.
Yeah.
that. Did it? Okay.
So group therapy does count.
So I've had, yes, Dauphin County has paid for all elements of my treatment.
They need to be approved by the SOAB.
Okay.
If they're not approved by the SOAB, it doesn't count.
And if the county's paying for it, you go where they tell you to, correct?
Yeah.
Usually usually the PO officer will tell you where to go.
Yeah.
If there's more options,
Can you
You
read
might-
any other questions?
I'm working on it.
You got it?
I
Okay.
got it.
if there's more than one option within your area, your PO might let you say which one do you want to go with. But usually they'll say this is who you have to go with.
A question in chat. This individual lives, I believe, in Indiana. And I don't know if, I assume he's still on the registry. So does the pre-existing offense exemption apply to move-ins from other states who have convictions prior to 2012?
So their offense occurred prior to December 20, 2012, and then when we went to Pennsylvania,
And just asking if he did, would he still be?
chances are he would probably still have to register under subchapter I.
But-
Don't take that as legal advice. We're not attorneys, so
Yeah, and that's, you know, kind of always the answer we have. We had
Yeah.
an email about this the other day and it's like, well, I don't know. I'm sorry. I wish I did, but I don't know. And I wish I could tell you more, but we really can't. Like, here's what the statute says and, you know,
But when you move, there's going to be paperwork that follows you when
Yeah.
you're like deregistering from your
I
state.
think that there's also a provision where, that they will look at, okay, which state has the higher.
Okay.
Years of term, of registering, and they'll defer to that. So if you're in Indiana and whatever you're on, it's in lifetime there, and then in Pennsylvania it'll be 25, you're probably gonna be lifetime moving into Pennsylvania.
this,
So with SORNA, that is just the breaking down, the person's broken down to one of those 3 tiers or placed in that, and that will make the determination of how long they have to register.
It's dependent upon which crime you commit.
yep,
Okay.
then you get assigned one of those tiers and it's 15 years, 25 years of life. that's
And-
worth it.
And also, I forgot to mention that if you commit a second crime again, it's an automatic tier 3 or automatic lifetime registration.
And this is kind of one of the faults of the system, right? Because you could commit, you know, one of these crimes and do your time and come out and really not be much of a risk. Or you could commit one of those crimes, come out and still be a risk, and you're both in the same category of 25 years. So that's what people in this movement talk about with reform, away from the tier-based system to a risk-based system.
And there are states who had that, but then the federal government said, no, you need to go to this. And so the federal government strayed away from the empirical tools outlet.
So failure to register, you wouldn't be placed into like a lifetime registry because you're just continuously failing. You would just more or less.
It's not a sexual offense. It's not one of those that would count as a second time.
Okay.
It's just it's an administrative issue that the simple fix for it is do not charge them with a federal or a misdemeanor or with a felony or with a misdemeanor. As Justice Saylor said in one of the opinions before he became Chief Justice in the Pennsylvania Supreme Court, he said the easier route to go for it to be non-punitive is give it a summary offense.
You got time for one more question? Any from the chat? No. Okay. Yeah, I'm really thrilled at the turnout and props to John, with great gratitude. This came out incredible and really grateful that y'all made the drive out here today. Thank you. All right.